Joining us is Zana Kaminsky, a law professor and director of the Criminal Defense Clinic at New York Law School, and Misty Marris, who is a defense attorney. And so let's talk a little bit, Misty, about what's been going on just in the last half hour with this kind of focus on Michael Cohen's sources of income before, during, and after Trump becomes president, and what he did for that income, and how that's now throwing on what this $400,000 plus payment was all about.
Absolutely. So you know that this is where the defense was going to go, because one of their arguments is going to be, well, this really was a retainer, whether or not it was more memorialized and it was in writing. It's not just the Stormy Daniels payment. It was more. You had these other consulting agreements. You made money from the Trump organization outside of that. So that's going to be one of the arguments that we see Trump's team making in closings. And that's why there's so much focus, because what they're going to try and say is, well, we called it a retainer. Well, that's not really improper. It's not going to fulfill that level of falsification of business documents. Now, on the flip side, you know, the Stormy Daniels payment is the lion's share of that. And Michael Cohen testified about structuring that payment as such in these $35,000 increments specifically to pay him back, plus his taxes. So, you know, of course, the defense attorneys are going to make that argument and poke holes, but I don't know if that's necessarily going to hold water at the end of the day.
And Anna, we've been reporting the jury reaction, how they aren't as engaged. Some rubbing their eyes, some holding their head in their hands, some looking around, watching people come in and out of the court. And I'm wondering, is this necessary? Does Todd Blanche need to continue on with cross-examination?
Well, we talked a little bit about this last week. This is that really hard balance, because what has to happen is, on the one hand, you've got to keep the jury engaged, right? You want them to be listening. You want them to be understanding what you're doing. On the other hand, if you don't get out particular facts, you may not argue them during summation. So right now, the defense is making sure it's getting out every single fact that it wants to be able to argue later on summation. And so that balance between, we're now, what, 2.5 days in? I mean, this has been a long examination with needing to get out every fact that they may want to argue on summation, and that's what they're dealing with right now. But listen, we've got to be mindful. They've got to be mindful that as jurors zone out, it doesn't matter that you tell them you got it out during your cross-examination. They may not have heard it because they got bored.